Greetings, everybody. My name is James. I am from the internet, and today we are going to be talking about the Supreme Court. Now, one of the fun, lasting legacies of Donald Trump as the former president, other than the fact that now, like, half the country says all the quiet, racist shit they used to feel inside out loud, is that him and Mitch McConnell effectively packed the federal court system with more than 1,000 judges directly off of lists supplied by the Federalist and other conservative organizations. They packed the appellate courts. They packed all the different levels of federal courts. And yes, they even left a few Supreme Court justices sitting there. So while we might want to think that all the other bullshit that we're dealing with still today because of Donald Trump is the rough part, this is where I remind you that the vast majority of judges, well, their judgeships are permanent, they serve for life, and very few of them retire. They literally stay in their respective benches until the day they die. So today, what I wanted to do is take a look at what the Supreme Court has been up to. And then I'm going to show you why they've been doing it. And yes, I promise that this story is going to get worse the further into it I get. So let's get started. Here we go. The U.S. Supreme Court is deciding more and more cases in a secretive shadow docket. Wow, I guess I wasn't lying when I told you it was going to get worse the further along we went. I just forgot that it happened that quickly. Sorry. Last week, it was Remain in Mexico. On Tuesday, the Supreme Court issued an order requiring the Biden administration to reinstate the Trump-era policy that required asylum seekers from Central America to stay across the border in Mexico while their claims are adjudicated. It was an uncommonly aggressive intervention into foreign policy, not something the Supreme Court does very often. 2 days later, it was the eviction moratorium. On Thursday, the court blocked an extension of the federal emergency ban on evictions, gutting a 1944 law that gave the CDC the authority to implement such measures to curb disease and endangering the roughly 8 million American households that are behind on rent and who now, without federal eviction protection, may face homelessness. Wow, it looks like the Supreme Court has been really super busy, and yet I feel like I haven't gotten to, read a bunch of the decisions from these cases. I mean, I've been hearing these decisions are happening, but usually when this happens, there's a lot of fanfare and there's stuff to read and then people can analyze it. And I feel like that hasn't happened. It's either that or I'm just not paying attention. Both of these orders last week were issued in the dead of night. Their opinions were truncated, light on the details of their legal reasoning, and unsigned. Vote counts were not issued, showing how each justice decided. And despite the enormous legal and human impact that the decisions inflicted, they were the product of rushed, abbreviated proceedings. The court did not receive full briefs on these matters, heard no oral arguments, and overrode the normal sequence of appellate proceedings to issue their order. Well, it would seem an entire branch of the federal government has just decided to go rogue. I would have thought that was the sort of thing that was going to take place while Trump was in office. And yet, a year later, here we are, Trump's gone, and his newly packed Supreme Court is apparently just going off doing shit willy-nilly, deciding whatever the hell they want that has consequences on literally hundreds of millions, if not billions of people. And there's no transparency. I feel like I've been watching this movie happen for a while now in slow motion, only it's a new cast of characters, and they're all wearing black robes. Welcome to the shadow docket, the so-called emergency proceedings that now constitute the majority of the Supreme Court's business. Minimally argued, rarely justified, and decided without transparency, shadow docket orders were once a tool the court used to dispense with unremarkable and legally unambiguous matters. To have an issue addressed on the shadow docket, a litigant has to apply for emergency relief, usually to stop a decision against them from a lower court from going into effect while the appeals are still in process. Traditionally, applicants would need to demonstrate that they would suffer irreparable harm if their petition wasn't granted immediately. So one historical use of the shadow docket has been in federal death penalty cases, where the court has used the emergency proceedings to affirm or deny requests for stays of execution. So what you're seeing here is the Supreme Court just following Congress down the rabbit hole where they find old-timey things that are rarely used and then start driving huge trucks of fucked up crap through it at a high rate of speed with absolutely no concern for precedent or need or necessity. This is just apparently what we're doing now is we're adjudicating cases and deciding whether or not laws are constitutional in the middle of the night and really not telling anybody why the decisions were made. This seems like something that would totally happen in a normal, healthy, thriving democracy, right? The term shadow docket was coined in 2015 by a conservative law professor to refer to the thousands of Supreme Court actions each term that defy the, quote, normal procedural regularity of the federal appellate process. A newer, expanded version of the shadow docket began to emerge in 2017 when the Trump administration came into power. What? No, there's a shocker. Shut the front door. Trump emboldened a whole bunch of people in the federal government to do some bizarre, janky shit and be okay with it? I'm shocked. I'm totally fucking shocked. Look, this is my shocked face. Previously, shadow docket emergency requests had been rarely used to advance the interest of the governing administration. From 2001 through 2016, the DOJ applied for these emergency relief interventions from the court only 8 times in 15 years. During the 4 years of Trump's presidency, however, the Justice Department applied 41 times because there is nobody, and I mean nobody, who loves suing people and or hiding behind lawyers like Donald Trump. He literally built an entire career on that shit. Of those 41 requests, the Supreme Court granted 28 of them in whole or in part, denying the Trump administration outright only 4 times, much more generous than the court has been to other litigants. Bypassing lower courts, the Trump administration was able to solicit the Supreme Court for a green light for border wall funding and construction, for a ban of transgender troops in the military, for a ban of immigrants from Muslim countries, and for many, many executions during the administration's 11th hour killing spree in the latter half of 2020. So basically, what I hear you saying is that the Supreme Court has gotten very Trumpy. Now, while this story by itself should be worrying and troublesome, and you should be concerned, you remember back in the beginning when I told you it was going to keep getting worse? Let me introduce you to worse. The Supreme Court has just 2 days to decide the fate of Roe v. Wade. What? How the fuck did that happen? This literally crept up out of nowhere. In a few months, the Supreme Court will hear a case that gives the conservative justices an opportunity to overrule Roe v. Wade, allowing states to ban abortion at early stages of pregnancy. But Texas can't wait that long. In May, the state's Republican lawmakers passed a law known as SB 8 that outlaws abortion after 6 weeks. Oh, okay, I remember this one. We did a video on this last week, and a whole bunch of vigilantes created a website that basically encourages people to create social mob justice and to go out and take pictures of people walking into and out of health clinics and then to upload those pictures to a central database so that independent investigators can then go and chase people down and find out if they were involved in any way in somebody getting an abortion. And if so, they would then have the power to sue them. And the people would get fined. The clinic would get fined. In fact, pretty much everybody would get fined. Now, at the time, I thought this law sounded a little odd, but I assumed it was going to kick around and then eventually get to some kind of appellate court. However, it turns out that that bill was far more fucking devious than I first thought. Texas Republicans purposely created and wrote the law this way in order to prevent federal courts from blocking it, and so far they'd succeeded. On Friday, the 5th U.S. Circuit Court of Appeals abruptly canceled a trial judge's hearing on SB 8's constitutionality, effectively allowing the law to take effect in 2 days on September 1st, which is now about 15 hours after this video will be posted on YouTube. This aggressive intervention has forced abortion providers to do what seems almost unthinkable. Ask the U.S. Supreme Court, the same court that agreed to hear a direct challenge to Roe v. Wade only a few months back, for an injunction in an emergency filing today on Monday. Their plea raises the inevitably bleak question: will the conservative justices who control a 6-3 majority of the Supreme Court let Texas overturn Roe v. Wade before they have a chance to do it themselves? So essentially, people are using that petition clause that I explained to you in the previous article. They're using that to demand that the Supreme Court give them some kind of injunction against this law going into effect until they can play through the appeals process. The chief goal of the way SB 8 was written was to evade review by federal courts otherwise obligated to enforce Roe v. Wade. Typically, when a state restricts abortion, providers file a lawsuit in federal court against the state officials responsible for enforcing the new law. Here, however, there are no such officials because they privatized it and gave all the rights to the citizenry to do whatever they wanted. The law is enforced by individual anti-abortion activists. There is no specific defendant to enjoin from enforcing the law. The state ensured that even as it runs afoul of current precedent, under Roe v. Wade, states may not ban abortion before fetal viability at about 22 to 24 weeks. This version of the 6-week ban will survive. Texas argues that abettors can challenge the law once it's enforced against them, but SB 8 locks all litigation in state courts that are now obliged to ignore Roe v. Wade. So the Supreme Court cannot punt now and then step in as soon as somebody files suit under SB 8. If the justices want to keep abortion legal in Texas, they must act before September 1st. Again, that's tomorrow, 15 hours after this video drops on YouTube. This 11th hour crisis left abortion providers with one last option: to ask SCOTUS for help. With the clock ticking, the plaintiffs sought an emergency relief from the Supreme Court. They asked the justices to issue either an injunction against SB 8 or, at minimum, to lift the Fifth Circuit Court of Appeals' bizarre order preventing the district court from issuing its own injunction. Their application puts the stakes squarely before the court. Texas, aided by partisans on the Fifth Circuit Court of Appeals, are trying to reverse Roe v. Wade before the Supreme Court even gets a chance to hear it and possibly overturn it themselves. Now, yes, that was certainly all a lot of mumbo-jumbo in the legalese that I just dropped there. But what does that actually mean in layman's terms? Well, it means that, number one, the Supreme Court doesn't have to bother to hear their plea. The Supreme Court can literally do nothing and still get what John Roberts and the majority conservative court wants, and that is to pick apart Roe v. Wade. Only the best part of this new way is that they don't have to do it. Now, I know you think that all conservatives, they want to put the big S on their chest, and they want to go out there and they want to be Captain Conservative. But when it comes to the courts and the Supreme Court justices, at most they want to be known as constitutionalists. They don't want to be known as conservative justices because then it taints their history, their legacy, and all these old school legal wanks. Legacy is really high on their list. So in many ways, this is far more preferable than them actually having to hear the appeal and then be the justices on record for the rest of history, who were the people who overturned Roe v. Wade with the stroke of a pen and made it illegal for women to get abortions. As much as they might want that to happen, none of them want to have their signature big and proud on the bottom of that decision. So this is going to allow Roberts and company to punt by doing nothing. And it will then open the door for other states with other virtue signaling conservative governorships and state houses who all want to suck up to Trump and the 15% of Americans that identify as evangelical Christians. Oh, they're going to come crawling out of the woodwork, and you're going to start seeing bills like SB 8 try to get pushed through other state houses, possibly in the state you live in. So everybody, you better keep your eyes and ears open on this one, because this literally almost happened during the middle of the night in total darkness. And another 15 hours, all the legal drama is going to be over before most people ever even knew it happened. Until next time, my name is James. I am from the internet and I am out. Peace.